tetukiriziganya n'eryo etteeka. Ekisooka nga Honorable Nambeshi wagambe balirese mutima mubi. Lwaki balirese kati? Lwaki balirese kati nga balaba lopa aliko abazoganya nnyo. So tumanyi bulungi nnyo, tubabuuzizza nti Gulu mwagamba nti mugenze okuteesa bya Northern Uganda. Kyajja kitya nti mwakkiriza lino etteeka okugira Gulu. Ate ne twogera ne ku speed lino etteeka lye litambulirako. Ensonga ezisinga tuzogeddeko naye ne tugamba nti oli akulembera oludda olwa government mu parliament bw'aba alondebwa, then n'akulira oludda oluvuganya ayina okubanga alondebwa ekibiina ekimusindika. Naye ne tubagamba nti baleme okukola amateeka nga abagakolera Finland oba wa tuli mu Uganda fena tumanyi ebibeerawo. Tumanyi bulungi nnyo nti bw'ogamba nti ono omuntu alondebwe, abo abali mu buyinza ababadde nga babukozesa bubi, ababadde bagulirira abantu n'ebirala byonna bimumanyi obulungi, bajja kuvaayo bagulirira abantu bagambe katono gwe twagala. Mukimanyi bulungi eno Museveni abadde nga avaayo agamba kati eno ye DP enungi, eno bad DP n'ebirala bwe bityo. Kati bwatyo bwe baagala okukola ne ku nsonga za leader of opposition. So tulowooza nti etteeka liva mu mutima mubi. Teri ggwanga eritambulira ku nkola ya Commonwealth eritambulira ku nkola bwetyo. So tetulikkiriza, tetukanya nalyo, era naffe tugamba nti ligobebwe. Naye n'ensonga endala tubuuza oyo lumu akolera ani? Bona aba opposition bwe babaze ne bagamba tetukanya n'eryo etteeka, lwaki ekintu kye tekijjayo n'akisuula mu kasasiro gye yakijja? Kubanga lwaki bw'oba ogamba nti oyagala kukiikirira kuyamba opposition yonna evuddeyo negamba totoonenera biseera, lino etteeka tetulyetaaga. Kati gwoba okolera ani okuinsisinga n'olemerako nti oli pushinga? Ensonga y'okusosolebwa gye njogeddeko nti eyo bw'oba ogamba nti kusayidi emu Nabbanja alondebwe, Museveni amulonde ajja akulire emirimu gya gavumenti mu parliament, ate n'ogamba nti Ssenyonyi yakubibwa akalulu kubanga ye wa opposition, ekyo kiba kireeta embeera y'okusosolebwa kye tubadde twogerako. Ti ne bw'okigezaako kiyisa mu mateeka kiri discriminatory, kubanga etteeka ligamba nti leader of opposition akulembera leader of opposition mu parliament, then prime minister n'akulembera government business. Ate si ekyo kyokka, bagamba nti nampala wa government, kubanga lumu ekirala kyagamba nti chief opposition whip, kati Honorable Nambeshi ye chief opposition whip mu parliament eno. Naye bagamba nti oyo ye akubibwa akalulu alondebwe, nti naye wa government, nampala wa government ye appointingibwe. Kakati nawe kiraba nti ekyo kiba mu mbeera y'okukola ki, y'okusosolebwa, ate amateeka gye kitakiriza.
I also fail to understand your concept of discrimination when Article 108A specifically provides for the manner of appointment and cessation of office for the office of the Prime Minister, compared to Article 82A, which gives Parliament the discretion to provide the manner for choosing a leader of opposition and how he seizes office. Two, the question of Article 82A, if you interpret it clearly, refers to a multi-party form of democracy and leader of opposition. Does not mention a leader of opposition political parties. So should we legislate beyond what the Constitution provides, which says a leader of opposition, and now we intend to legislate for other opposition political parties? What is the purpose of the Administration of Parliament Act as opposed to the purpose of the Political Parties and Organizations Act? Lastly, from me, you've not
on the violation of the Constitution. Chair, I'm alive to a fact that quite a host of authorities, Supreme Court decisions have been made, which have guided us on how we do the interpretation of the Constitution. I raised my concern particularly on the presentation which started from page 1 on the issue of discrimination of the Secretary General, yes, of NUP, where alludes to the fact that there is discrimination. But interestingly, when he was making that presentation, he alluded to 3 articles of the Constitution. There was Article 21, where he made reference to political discrimination. Then he made reference to Article 82 and Article 108. Now, the rule of harmony requires that the Constitution is interpreted as an integral whole. Whereas the allegation which is put forward is that the way the Prime Minister, for example, is put in office, the Prime Minister that's a constitutional office, and the mode of putting the Prime Minister is through an appointment. It is expressly stated in that provision. If you look at our Article 82, it gives the mode. Yes, it establishes the lead of opposition. That's crystal clear. But on the mode of us choosing the lead of opposition, that power is given to Parliament. I want to agree and look at the arguments which were subsequently raised, but I wouldn't really want to buy into the argument that by the mere fact that the Constitution provides one for appointment and that is discrimination. It is not. That is the provision. We follow the law the way it is. So I don't think it would be good for you to construe that as a total discrimination, because the mode is expressly stated in the Constitution. If the Constitution had so stated that even the Prime Minister should be elected, that should have been the process, isn't it? So that particular aspect, I want to appeal and make a submission that it doesn't augur well and say perhaps the ruling party is having that discrimination in the way things are done. That may not be proper. So the other concern that I have, when I look at your presentation, it is true you made reference to Article 8.1 of the Administration of Parliaments Act, which empowers the main opposition party to appoint the law. But you'll also agree with me that the Administration of Parliaments Act is the one which operationalizes Article 82 of that provision operationalizes Article 82 of the Constitution. I would perhaps bend so much in getting your argument on why you think that the mode of election may not be the most appropriate. You get it? As suggested by the mover of the bill. Because if you look at that, you carefully and I am very alive to the fact that certain officials who are permitted to cover parliamentary proceedings have been taken through certain training. So I want to appeal to a colleague who is doing the recording, live recording of our proceedings here. Kindly address yourself on those particular rules. Because if you read those rules, it talks about the angle, it talks about the manner, professionalism. Those people know what is supposed to be for the public consumption and what is not supposed to be. So I want to request that.
You have a colleague who is recording?
Yes.
MPs can be bribed by government. How sure are you that your president may not be bribed by the same government? Because if you give him chance only to designate the leader of...
The law is not just a leader of the opposition for the party with the biggest numerical strength. It's a national office established by the Constitution. It serves all, the entire country. It's just not limited to NUP or FDC if we are the party with the biggest numerical strength. It's a national leader.
To the same scrutiny of the appointments committee, like the chair has been proposing that the government people go through that process. How would it be compared to the ministers vetting the government chief whip? I would want to ask the colleagues this side of the new people, how would you feel, or how would you take it?
Should be rested. There is no speed, it's just taking its normal course. And then I can now weigh in on the issues before I invite members. Now, under the current status quo, the Vice President, once appointed by the President, is approved by the House. Actually, the Vice President could be rejected by the House. If the name is brought for approval, the House could actually reject. Same with the Prime Minister. Goes through an approval by the House, which means that that name could be rejected. Now the ministers, once appointed, go through vetting by the Appointments Committee, which is bipartisan. We have members of all parties there, chaired by the Speaker, and the LOP is a member. Now, you can see that all the officers appointed by the President, the biggest party in the government, which is in government, they go through some process of either vetting or approval by the House. Now, the opposition, the leader of the opposition, who is designated by the party with the greatest numerical strength in the opposition, that party has a blank check. Has a blank check by way of just designating and informing the House. There is no requirement for the House to approve. The name is just brought for the information of the House that the leader of the opposition is so and so. So it is a blank check in my view. I want you to think on how can we tour the idea that it is a blank check. Maybe we need some processes through which that name could be approved, or other than elections as proposed. Which other way do you think would hold the party in opposition to accountability by way of either approval by the whole House or through vetting, as it is with the ministers that are appointed by the President? That's the first one. I'll invite the other colleagues to take on the matter.
And therefore the bill doesn't remedy anything. In conclusion, Mr. Chairman and members, it is my humble, considered opinion that the bill doesn't seek to cure any legal mischief in the existing law. I'm of the considered view that the status quo be maintained in the spirit of strengthening multi-party political dispensation, as was envisaged by the framers of our Constitution, and in keeping with the standards that I have lighted above. Mr. Chairman and honorable members of the committee, I beseech you to reject this bill in its entirety. I beg to submit.
Thank you, Honorable Nambeshe.
Chairman of the Council of State, or the Speaker of the House of the People, as the case may be. Criteria for recognition. There are two conditions that need to be fulfilled to recognize a person as leader of the opposition, Mr. Chairman. One, the party should be numerically the biggest one in opposition to the government. Two, the party should have 10% representation in the House of the aggregated number of MPs in the House. In fact, in the Indian Parliament, the leader of the opposition in Lok Sabha incidentally, Mr. Chair and honorable members, means the lower house. The upper house in the Hindu language is called Rajya Sabha. Now, this one, the leader of the opposition in the lower house is considered as a shadow prime minister with a shadow cabinet ready to take over the administration if the government resigns or if the government is defeated on the floor of the House. What is the practice of choosing leaders in a multi-party political dispensation in Uganda? Mr. Chairman, every political party is independent of the other in terms of ideology, aspirations, and principles. It is on this basis that parties present their manifestos during elections, the premise on which electorates vote candidates or parties of their choice. Two, there are lots of consultations that go on in the background with various stakeholders before the final position of leaders is brought to the House for approval. A case in point, Mr. Chair and the colleagues, is the NRM cabinet that has a cocktail of political parties in its cabinet who are appointed solely by the President, whereas in the opposition, shadow cabinet is constituted from the entire opposition membership, irrespective of party affiliation, by the official opposition party in the spirit of consensus. Each political party is independent of the other ideologically, and now bundling them together for the sake of the election of the leader of the opposition, Mr. Chairman, would mean denying them their rights given under the Constitution, as per the article I have actually quoted, Article 29. And in fact, to emphasize this, every political party in the opposition has its own party whip for purposes of relaying its members to toe its party lines. Grounds for one to cease to hold the office of leader of the opposition. One, as it stands, the Constitution, the 1995 Constitution of Uganda, as amended under Article 83, it stipulates grounds on which one ceases to be a member of parliament. And these same grounds still apply to the removal of the leader of the opposition. Two, and also the rules of procedure stipulate details of what constitutes misconduct, and also how one can be dealt with. And therefore, having this as a justification for amendment of the Act is uncalled for. Section 6C of the Administration of Parliament Act 2006, as amended, has already settled the manner and the grounds for which one ceases to hold office as a leader of opposition. The official opposition derives its mandate from a general election as a first run-up. Hence, one cannot remove the power, authority, and the mandate that is earned, I emphasize the word earned, at a general election through a mere procedural amendment. Therefore, this particular clause, Mr. Chairman, in the bill is redundant and does not offer any remedy, and thus should be rejected. Status of the leader of the opposition. Section 6D of the Administration of Parliament Act 2006 accords the leader of the opposition the same status as a cabinet minister, and therefore stripping him or her of this status by subjecting him or her to an election and leaving out his or other counterparts in the ruling party who enjoy the same status would be absolutely discriminatory. Thus, this opinion should stay as it is, since passing it in this current form, as proposed by the move of the bill, would be counterproductive and would be discriminatory. Election of the chief opposition whip. Honorable Chair and members, the bill proposes the election of the chief opposition whip by opposition parties represented in Parliament. The office of the chief opposition whip is a creation of Section 6I of the Administration of Parliament Act 2006, and rightly so, the same applies to government chief whip under Section 6H of the same Act. That means the Act enjoins government chief whip and chief opposition whip the same status, and hence an amendment should apply to this same, an amendment to this same section, because both government chief whip and chief opposition whip are creatures of the same Act. Now, an amendment therefore should apply across board rather than doing it selectively. The proposal is discriminatory and violates the Bill of Rights given to us under Article 21 of the Constitution of our motherland, Uganda, which talks about equality and freedom from discrimination. And goes further, I've quoted, I will not read this, but goes further to say that we should all enjoy equal protection of the law. Appointment of the chairpersons and the vice chairpersons to parliamentary committees. These are sent to these positions through a consultative process that happens behind the scenes. No wonder some committees that are to be chaired by the government side are chaired by some MPs that don't belong to the ruling party. You all know this. It's crystal clear. Similarly, in the opposition, we have chairpersons of accountability committees that don't belong to the official opposition party, in the spirit of don't leave anyone behind, but rather move together as a team, which National Unity Platform has demonstrated by word and deed. In the light of the above, I pose the following questions respectively to the committee. Does this bill pass the following quality controls and standards? 1, the standard of multi-party political dispensation. 2, the Commonwealth standards, practices, norms, and traditions. 3, the governance standards, which are literally a principle of good governance. The amendment disregards internal party processes, weakening overall political party democracy. The proposal disempowers political parties by stripping them of control over their members in parliament. If passed in its form, this bill, this legislation would kill multi-party democracy, as the leader of the opposition could not be answerable to any party, but to individual members of parliament. Consultation is before the motion seeking leave was granted. Courts have held in Mare Mabilis versus Attorney General and the Parliamentary Commission that before a private member seeks permission to present a private member's bill, he or she must conduct thorough stakeholder consultations. This particular bill before the committee is void of this standard, Mr. Speaker, Mr. Chair, since there is no evidence to that effect that the mover held consultations before seeking leave to come up with this bill. In fact, it is on record that the Democratic Party that he belongs to was not consulted. Another important issue that this committee should interest itself in is what constitutes an opposition party. As it stands, there is a lot of ambiguity for that term. Ambiguity, for example, how would one describe or refer to political parties that have memorandums of understanding with the ruling party, and thus this shouldn't be lumped together as opposition to choose who the leader of opposition is. I have tried to peruse through and make a few consultations here and there, and I'm here to come across a country that elects the leader of the opposition. I'm on the last page, Mr. Chairman. In my opinion, it doesn't meet this bill does not meet any of the above standards, and thus borders the breach of the tenets of democracy and good governance, and is an insult to the Commonwealth practice and norms. Finally, the issues being raised by the move of the bill are administrative rather than legal in nature, and thus there is nothing wrong with the current legal framework, the mother of democracy that we refer to. The position of leader of the opposition is officially described in an act called the Salary and Allowances of Leaders of. Sincerely express my gratitude.
The document is quite voluminous. You'll have to.
No, it is the font.
The font.
Which is bigger than the usual.
Okay.
But it is very brief. Colleagues, I want to express my gratitude to you for extending an invitation to me to come and share my insights and thoughts about the Administration of Parliament Amendment Bill 2024 that is before the Honorable Committee. Honorable Chair and colleagues, as you are already aware, the Administration of Parliament Bill 2024 was tabled and read for the first time on the 1st of
we take on all the presentations that go.
Thank you, Mr. Chairman.
Only 6 minutes. We will allow the whip, the chief opposition.
Deepen multi-party democracy or not? That should be the overriding question. Does this bill, in the view of this committee and in the view of the mover or any other sensible Ugandan, presume that by providing, as he proposes, that would deepen multi-party democracy, or would seek to stifle it? We wish to emphasize, honorable members, that our strong opposition to this bill is not in any way premised on any intention to strengthen or maintain our stand in the opposition as NUP. In fact, Honorable Chair, the National Unity Platform works day and night to ensure that it takes power and builds a new Uganda. Our opposition to the bill is premised on our firm belief that even if NRM was to be the main opposition party, as we know it will be in opposition sometime, it should not be crippled in its operations by using very bad laws like the present proposal. We invite this committee to reject it in its entirety and ensure that we do not seek to further aid the breakdown of the rule of law. I thank you, Honorable Chair and members. At least once every 2 months. And from the time he became LOP, he has not been allowed to attend any. And so we ask ourselves about the timing. Why now? Why not before? Why? We think that there is bad faith, certainly, and the current LOP is being targeted through this law. Besides being denied his right to attend meetings of Parliament's top administrative organ, the Parliamentary Commission, since his appointment as LOP, Right Honourable Senator has also been denied the privilege of hiring trusted policy analysts and other key staff in his office, contrary to the practice that has been followed since the position was created in 2005. You all recall, honourable members, again citing bad faith, that where Right Honourable Senator strongly opposed and led other MPs in boycotting the sitting in Gulu. To get back at him on August 29th, parliamentary sitting chaired by the Speaker granted Honourable Lumu leave to introduce the instant bill, seeking to clip the LOP's wings in a manner that we are highlighting. This was despite the Speaker categorically stating that only matters exclusively related to northern Uganda would be discussed in Gulu. How was the introduction of this bill in any way related exclusively to northern Uganda? This committee must therefore not accompany the mover of this bill on a journey that was birthed and nursed with sinister intentions, bad faith, far from Article 79 of the Constitution, which enjoins Parliament to legislate for good governance. To further show the mover's ill intentions, the bill proposes that the LOP may be removed when he or she misbehaves. Now, members, who determines misbehavior? Who defines misbehavior? Where you say that if someone misbehaves, then the person should be removed. What is the standard of misbehavior? Who defines misbehavior? What standards will be followed? Well knowing that different individuals and parties may have different standards for misbehavior and indeed incompetence. We have some parties or individuals in this country who may see corruption as not bad behavior, but calling out corruption as bad behavior. So how do we determine what misbehavior amounts to? And we see that the mover is deliberate on putting such vague grounds so that it's very easy to remove the LOP whenever the members are influenced either way. In any case, like I highlighted earlier, under Article 108A of 4 of the Constitution, the Prime Minister who leads the government side can only lose his or her seat when he or she resigns or dies, or when the appointment is revoked by the President, or when he or she ceases to be a member of Parliament. There is no possibility of removing such a person by a resolution of the ruling party MPs on vague grounds such as misbehavior. And we strongly feel it's unfair to say that for the Prime Minister who leads the government side, there's no provision even for such a person to be removed otherwise except those grounds which are specifically stated in the Constitution. How can anyone suggest that the LOP, on the other hand, should be removed over flimsy grounds like that? Providing an avenue for arbitrary removal of the LOP would destabilize the opposition leadership in Parliament. The leader of the opposition would have to be constantly on tenterhooks, seeking to appease the MPs on both sides to avoid that instability and the possibility of removal. All this go to show the bad faith in which the proposal is made. The timing of this proposal, considering that we have had different LOPs in the past, makes clear the true intentions. We are convinced that the bill is intended to tame the LOP and significantly weaken that office. It is a continuation of what happened when Honorable Zake Francis was illegally pushed out of the Parliamentary Commission when he started asking uncomfortable questions. The unconstitutional manner in which he was pushed out was confirmed by the Constitutional Court of this country. In addition to the foregoing, several other clauses of the bill raise more questions than answers. For example, where is the logic in the main opposition party nominating the LOP, but thereafter this LOP is not required to consult the party that nominated him or her, as clause 4 of the bill proposes? What does the provision that two commissioners shouldn't be from the same party imply regarding the nomination? Because the mover, under those additional clauses, says that, there should be two commissioners from the opposition who should not come from the same party. And we are saying that that would be a recipe for disaster. Doesn't it deprive the main opposition party of a commission on the Parliamentary Commission, since the bill essentially means that all opposition parties are entitled to nominate candidates for the two commissioner positions that are being proposed? And that would create the Yala situation, which we already alluded to above. Conducting elections among all opposition MPs and gaining broad approval for appointments will require substantial time, resources, and procedural challenges, thereby resulting in frequent deadlocks on key appointments. Similarly, the requirement for multi-party approval in the shadow cabinet's formation and committee leadership would slow down decision-making and create inefficiencies. This bureaucratic layering could hamper the opposition's ability to quickly respond to government policies. In conclusion, Mr. Chairman, Honorable Chair and members, the question that this committee should ask itself is, does this provision, this would undermine the largest opposition party's ability to assert its role as a primary check on government authority within Parliament, as well as its ability to hold parliamentary and other government officials accountable. It would also compromise the LOP's role by enabling the ruling party to influence decisions through members who may be more sympathetic to the ruling party's interests. Secondly, there is a likelihood that opposition MPs may be bribed or compromised or unduly influenced by government to vote a LOP agreeable to the ruling party. We all are in Uganda. We are not from Mars, Honorable Chair, and we know what has been happening in this country. There have been several reports of MPs being compromised to pass controversial laws and proposals by the ruling party. We are concerned that even this time around, the ruling party may seek to compromise opposition MPs to vote certain candidates for LOP, whom the ruling party finds agreeable, which shouldn't be the case under a multi-party system. Honorable members, I invite you to consider Yala elections, for example, and you see it is strange that the largest opposition parties for long have not had a chance to send representatives to Yala. You will recall that in 2016, the chairman of NRM, General Museveni, publicly said that there is good DP and bad DP in an attempt to influence the voting of members of parliament in that Yala election. And indeed, those who are considered good DP found themselves able to sail through under that arrangement. Not all MPs considered opposition actually oppose the government. That's also another point. It is misleading to suggest that members of parliament who did not come to parliament on the ticket of the ruling party are actually in opposition. In the case of NUP, for example, honorable members, in the case of NUP, consider the case of Honorable Twa Kagabo, Honorable Jimmy Rwanga, and others. Although these members came to parliament under the NUP ticket, they have been categorical, stating it publicly that their current allegiance is to the NRM, to a point of attending NRM caucus meetings. Now, members, are these the people who would be expected to elect the leader of the opposition in parliament? Would these kinds of people be expected to objectively refrain from moving countless motions to remove the LOP on frivolous grounds. People who have already indicated, although they are seemingly on opposition, but their allegiance and interests are elsewhere. In this regard, therefore, Honorable Lumu seeks to hand over the opposition to the NRM or any other ruling party using this absurd proposal. Worse still, it would be absurd in the present context to assume that every political party that is not in power is actually in the opposition. What do you make of the Democratic Party, for example, or a section thereof, which currently has a cooperation agreement with the NRM? Or the UPC, which General Museveni recently said are very good allies to the NRM. Should a political party in cooperation with the ruling party participate in electing a leader of the opposition, whose cardinal role is to keep that same government in check? It would defeat basic logic. We also invite this committee to reflect on the reality that political parties in the opposition are not homogeneous. Although we are all branded opposition currently, we have distinct ideologies, policies, and approaches to different governance issues. You cannot suggest that opposition parties are homogeneous, therefore. Even though they may operate within the same political system, each opposition party represents a unique set of values and priorities. This diversity must be guarded when deciding the opposition leadership in Parliament. Failure to do so would impose undue influence on the internal decision-making processes of the main opposition party, thereby hampering the multi-party system that the Constitution was deliberately designed to protect. Inadequate consultation, the manner in which the bill is being fast-tracked through the parliamentary processes, to the extent that its mover felt compelled to smuggle into it additional clauses that were not part of it at the first reading and at the time when he obtained the certificate of financial implications, has militated against sufficient consultation of all stakeholders. This is a violation of the constitutional requirement for participatory democracy in lawmaking, which renders the bill illegitimate and unconstitutional. Clearly, the leadership of Parliament, in our view, is giving this bill priority, despite the evident lack of preparation on the part of its mover, which raises disturbing questions about the true motives behind its presentation. Rejection of the bill by all major opposition parties. Mr. Chairman and members, honorable members, besides NUP, all other opposition parties that have appeared before this committee, including FDC, UPC, and ANT, have rejected this bill. And in fact, if you follow media reports, even those parties which are allowed to be consulted on this matter, all rejected this law. This is a resounding vote of no confidence in the bill by the person by those who would have been the biggest beneficiaries and main stakeholders, strips the bill of legitimacy. I mean, if this bill was meant to help the current opposition, and the entire current opposition is saying no to this bill, the question this committee should ask itself, whose interests is Honorable Lumu trying to push by insisting on such a law? The Administration of Parliament Act already outlines procedures for the selection of the LOP. Any amendment to this process must align with existing legislative frameworks and respect the Constitution and the Act's intent to empower the leading opposition party in its oversight role, an intent that this bill terribly contradicts. Under number two, another broad reason, the timing and context of the amendment indicates bad faith. It is public knowledge, Honorable Chair and members, that the leadership of Parliament, the current leadership of Parliament, has engaged in a pattern of hostility and antagonism against the current LOP by creating and sustaining an environment that sidelines and marginalizes him in key parliamentary processes and decisions. And we give examples where the National Executive Committee designated Honorable Joel Senyonyi as LOP, and that by that designation he particularly became a member of the Parliamentary Commission. But we understand that Right Honorable Senyonyi has not been invited or allowed to attend any Parliamentary Commission meeting at the Parliament of Uganda ever since he was designated LOP. Now, these meetings, by dint of Section 18(1) of the Administration to the law, by the move while appeared before you, for the sake of democracy and good governance, the National Unity Platform opposes this amendment bill in its entirety, and we base our strong opposition to this proposed law on the following grounds and context. One, we believe that the bill violates the Constitution of Uganda and the established democratic principles. The bill in its current form unjustifiably discriminates against opposition parties and their members of parliament on grounds of their political opinion, which is prohibited by Article 21 of the Constitution of Uganda, which prohibits discrimination on grounds of political opinion, among others. And I can give examples. One, it discriminates against the leader of the opposition's business in parliament vis-à-vis the leader of the government's business in parliament. Article 108(1) of the Constitution designates the Prime Minister as the leader of government business in parliament, while Article 82(a)(1) effectively designates the LOP as the leader of the opposition's business in parliament. To achieve this, the party in government appoints the Prime Minister, while Section 8(1) of the Administrative Parliament Act empowers the main opposition party to appoint or to elect the LOP. However, Clause 2 of the bill intends to introduce a discriminatory approach whereby the LOP would be elected by all MPs of the various opposition parties in Parliament, yet there is no similar requirement for the Prime Minister to also be elected by those who subscribe to his or her political party. Furthermore, Clause 3 of the bill, which introduces additional grounds for removing the LOP from office, is discriminatory in the sense that these grounds would apply only to the leader of the opposition, but not to the leader of government business, who is the Prime Minister, yet the two play parallel roles. Providing for the removal of the LOP by resolution of all opposition members of Parliament, and not providing for the same for the leader of the government business, is not only discriminatory, but would be a direct affront on the opposition. Number two, it discriminates against the chief opposition whip vis-à-vis the government chief whip. And Section 14(1) of the Administrative Parliament Act provides for the appointment of a government chief whip by the ruling party from among its members. Please note the word appoint, that's what it provides for. Section 15(1) of that same act provides for the appointment of the chief opposition whip by the opposition party having the most members of parliament on the opposition. However, Clause 3 of the additional amendments now introduces a discriminatory approach whereby the chief opposition whip, unlike his or her colleague on the government side, would be elected by members of the opposition, which would be discriminatory and wrong. Worse still, whereas the bill is being touted as a tool for increasing efficiency in the opposition, it proposes that the new role of the chief of opposition whip would be to ensure the attendance, participation in proceedings and voting in parliament by all members of opposition parties in parliament, contrary to the prevailing situation where each opposition party has its own whip. Effectively, that means that the logical reasoning would be that there should be one whip for all opposition parties, yet the ruling party will have its own whip, which is not shared with any other party. Number three, the proposed law undermines the autonomy of opposition political parties, thereby weakening constitutional checks and balances. The bill disregards Uganda's constitutional framework, which envisages a multi-party system where each political party retains the authority to manage its affairs. It specifically infringes on the right of the main opposition party to self-regulate and appoint its leadership in parliament. Yet, in nascent democracies like Uganda, each political party must retain the autonomy to select leaders who best represent its ideals and policy positions. By proposing provisions that allow multiple opposition parties to participate in the selection and removal of the LOP, the bill unconstitutionally attempts to circumvent the role and influence of the largest opposition party and usurp the will of the citizens who voted for it ahead of any other opposition party. And I think this point has been made that under a multi-party dispensation, the Westminster system, the presumption is that there is a party in government and there is a party in opposition. The main party in opposition, therefore, effectively forms government in that sense. And that is why there is even a shadow cabinet and all those. This bill, as well as some of the new clauses that in our view are smuggled into...
Sorry for the interjection. I want to invite you to a cup of tea.
Thank you very much.
And also I've been joined by a member, Honorable Yona Musinguzi, MP Ntunga Municipality.
Representing the people of Okoma Simbi South, a member of the National Unity Platform I'm the senior backup here.
John Taylor, Bugabla County, North Kamuli District. I'm the deputy chair of this committee.
I'm Willie Peter Christopher, Member of Parliament, Uwolo West Manafa District.
Member of Parliament, Bamunanika County, Ruero District, a proud member of National Unity Platform. Thank you.
Wilfred Nogavandura County East.
Morning, Honorable Chair and members. My name is Sasmavin. I am the Secretary for Diaspora Affairs of the party.
Greetings, members. I'm Zake Francis, and I represent the young people.
Honorable Chair, my name is Alex Waiswa Mufumbiro. I'm the Deputy Spokesperson of NUP. Thank you.
Honorable Chair and member of the National Unity Platform. Thank you.
Unity Platform in charge of Eastern Uganda. I will again come back in the capacity of Chief Opposition Whip because I've been invited.
So we'll start with introductions of the stakeholders and then the members of parliament lastly. Madam President. As we are connecting direct to the next stakeholders who are already here. So can I invite the leader of the delegation to take up the first seat?
One concern. At the very onset, when we started considering this bill, I remember it had there were additional clauses. We were supposed to have had a reprint. So I want to be guided by you, Chair, whether we subsequently dropped those other, because I look at the presentation even of my senior is strictly on one particular aspect. Yet
in the deliberations of this committee, as because I'm not a member, but I want to learn from my senior colleague.
Once admitted, you now have all the rights.
Thank you, Honorable. Thank you, Honorable Chair. Now, because we are handling the Administration of Parliament Act, and we have occasions where the opposition has submitted its position of redesignating members, for example, the commissioner, the chairpersons and deputies of the committee, and the rules are very clear. You can redesignate at any time. A party makes a submission through its whip and the LOP to the floor of Parliament, but these members are held to those positions by the Speaker. So these are the issues that we want to put, we want to bring out clearly. This is a committee on parliamentary and legal affairs, but these matters are keeping on happening, but no one is talking about them. So the fact that we are looking at the Administration of Parliament Act, some of these issues must also come out if you are looking at amendments.
Chair, I think as political parties in opposition, not as opposition, we should really respect the will of the people as reflected in our democratic elections. So if a party with a second numerical strength is not given the discretion and power to appoint a leader of opposition, and also to appoint the leadership like shadow cabinet, and also to appoint commissioners representing that party, and you subject this to Parliament, whether under the control of presiding officers, like what is happening now, this is going to be disastrous. No one is going to benefit, because the purpose of the party in opposition, or what you call opposition, is to create checks and balances. And these checks must be controlled by the political will outside the Parliament. Like the president is controlling the NRM, which is the ruling party in power, by appointing cabinet, by reshuffling cabinet. So we should not interfere with the power of this party with the numerical strength to determine and control leadership on matters of policy in Parliament. Point on governance. Okay.
Okay. So you can now.
Much, Honorable Bosco, of course, raised something novel, but when you look at the debates of the constitutional amendments by the second Parliament and even the parliamentary amendment of the Act, the spirit really looked at the party with the second numerical strength. It was really meant to ensure that alternative policy can be debated in Parliament in a coordinated manner. It must be presented by a person who has some bit of authority, ostensible from the party. So basically, if you're talking of an amendment now, you cannot do away with that spirit of the constitutional provision, because that would be unconstitutional. Then the other point raised by Honorable Nwagaba, of course, it is a big problem. Personally, I believe without a coalition government, members who are in this government as ministers from different parties, the opposition parties, their appointment was irregular and void. It is clear. You see, you cannot talk about now a party entering into a memorandum and separate, because the party does not belong to the leadership. It's an institution. It's an institution. That's why it is funded by the state. So you cannot come here and individually and you talk and you get positions that will be now an infringement. Unless maybe you go through your parties in a proper organ like a National Delegates Conference or something, and you are really designated and even approve those so-called agreements which you are doing clandestinely as individuals. Otherwise, the party does not belong to you. It is an organ. And that's why actually they say parties must have a constitution, must have this, you must have regular meetings, meaning you must give the parties that to get the will and direction of the people. The directing mind and will should not be reflected in individuals, but it must be reflected in organs. Then
party with the second highest number of votes only. And two, other than a coalition under Article 69, sub-Article 2C, what do you take of the current status where you find a member of UPC is in a cabinet, a member of DP is in a cabinet? What is the legal status of those members? You are reading of Article 82A of the Constitution. Does it strictly relate?
Such an elaborate presentation, and surely one thing which comes to mind is that we are doing this also as a committee. We can't reject something which has been brought to the committee. We process with all fairness. But I don't know what would be I'm happy of giving your suggestion that you would still suggest that it's proper to toe the line of designation by the majority opposition party, if I may call, with the second highest majority, second. But I don't know how you would be able to, if you looked at Article 82A, sub-Article 2, where it actually gives the leeway to Parliament to take a decision on how the mode of operation, you get the mode operandi, how we can be able to operationalize that provision of the Constitution, how the leader of opposition should be chosen. I don't know how you can manage up with it, because when I look at chosen, designation can be one of the forms, but it gives the leeway to Parliament to take that decision, which I think it's not offensive on our side. What would be your take on that?
Chair, as I had also declared my conflict of it, but just to thank, gave our views. It has not been easy to harmonize the leadership, the membership here, and ensuring that we move together. But Alhamdulillah, I hope everything will go on well. Of meat, but given the time constraints, I'm very grateful. I lay on table my presentation. I pray that you consider our views as FDC and wealth. We cited UK, Ghana, India, Tanzania, and Kenya, South Africa, where the party having the greatest numerical strength designates a leader. There's no constitutional provision creating opposition, so to conscript all opposition parties as opposition, it is it's not even proper and it's not practical. At our level, we can consult as politicians, but we should not be conscripted as opposition because it's not workable. And then we suggest that the party with the second numerical strength should be given the power to designate. We should not undermine the strength of such political party, and we should not delink the leadership there from parliamentary control by such a legislation. That's my... the bill goes at independence. Now, if you go with this kind of argument and justification as Honorable Rumo is talking about, then you also have independents. Actually, now independents are more than other political parties. So I think the idea has nothing to do with representation. In fact, when you look at this act, if you have issues, it goes to your whips. And the law is very clear. Each party has whips. If you have now matters at that level, then you harmonize your positions in the different parties through your whips. I'm a whip myself. It is a weak office, but the weakness is the administrative, and that can be handled without legislating and conscripting all parties as opposition. No, it is impossible. Personally, I came here as FDC. You cannot conscript me as opposition to have common positions under opposition when the law did not envisage this. Then, Honorable Chair, we made comments on page 3 about clause 3, 4, and 4B. I think the same arguments request that should be adopted, mutatis mutandis. Then, Honorable Chair, because I just have a few minutes, we made bullet forms from page 4 up to 7. They're just 7 pages. I just want to talk about summarily about those bullet points. Our general concerns about the bill, the law or the constitution envisage a coalition government. So what if one or two parties now entered into an arrangement with the government? Do you now look at those people as eligible electoral college members to sit and appoint a leader of opposition? We've just had Honorable Mao here. I don't know whether he's cohabiting, already married to the but in such a situation now, if you have now a member, with all due respect, because he's now a member of the opposition, with powers to appoint a leader of opposition. But you don't know whether he's cohabiting or really married. So in such a situation, we have individuals cohabiting with the government, or those who are actually married to government, or those who have entered into a coalition under Article 69. What happens in such a situation? Then we also have a situation where issues of party discipline. In a multi-party dispensation, if the leader of opposition is not really behaving or not yet towing but agreeing with the party position, then you have a problem, a very big one. And you say, no, you have no control over me. I was elected by members of parliament. It really is quite different, because now if the chief whip or the leader of government business, the prime minister, is indisciplined, the president can easily say, I've reshuffled. So here, now the mandate is with the parliament, and you have no control. So it is a big problem also which you have to look at. Then, Mr. Honorable Chair, under our clause 6 on page 4, there are circumstances where you have the minority of the minority who may not agree with the majority of the minority. So within the minority parties, or on the opposition, as we call it generally, they may not agree with the majority party. I'll give an example. Now NUP is the majority of the minority. But then you have a party like a JMA with one MP. It is in the minority. So you find that entire group of the minority, you understand what I'm talking about? The minority of the minority now disagreeing with the majority of the minority. It's a problem. You find now NUP is in charge, is the majority of the minority, but then you find a grouping of other parties, the minority of the minority, now controlling the majority of the minority. So it doesn't really make sense legally. And now you are legislating to give powers to parties which you are really representing the minority of the minority to control the majority of the minority. So there's really a very big problem. Then we were not consulted. That is another problem, even as whips. Actually, Honorable Rumu is the de facto whip of what? Of DP. But even at our level, informally, Honorable Rumu has never talked to us. So we really are wondering what is the genesis and the purpose of this bill. You know, he's now stampeding the bill as if he's representing and protecting opposition, but he has never had the courtesy of even talking to us. And he's the de facto, actually, he's the de facto whip of DP, with all due respect. So I think that one we cannot associate with a bill where there was no consultation. Then, Honorable Chair, I think I'm about, because I have other...
They are going down, now we say. Actually, the state that would come in dispute would only be mental, and he has not alluded to that.
So what I'm saying, Honorable Chair and Honorable Members, that really subjecting election of such an important leader, who is supposed to now pass on government, alternative government policy, and do all the checks in the hands of different political parties with different manifestos, actually with different challenges. They have even their own political issues internally. So I think that is going to cause more confusion in Parliament. And it is our submission that actually the leader of opposition should be by the party with the second numerical strength. Having made that point, I just want to note also
that a senior colleague is going down and is deteriorating. Are we proceeding right? I don't know whether in the current state that is in, whether we are proceeding right. That is.
Well, thinking about you see, electing a leader of opposition by the political parties, it is going to cause disruption This institution is not very easy. It is so,
you know, Chair, it is not.
I'll try my level best. Yeah, Your Honorable Chair and Honorable members, have a brief write-up which I want to lay on the table, and then I will just highlight a few areas. So I also have copies for members. Okay. Yes, Honorable Chair, I'll be very brief and look at clause by clause. The general areas I'll give a just a general comment. Specifically, Honorable Chair, we are concerned with what the mover referred to under 1.0 objective of the bill. We believe he's blowing both hot and cold by recognizing the principle of democracy that there must be a leader of opposition by a party with a numerical strength, at the same time subjecting the party's will to election by members of parliament of opposition parties. So I think he should have really considered that this determination of leader of opposition has to be by the party, and that is really positive. But at the same time, it now is subjecting this will and discretion to an election of members of parliament of what refers as to opposition. And under our 2.0, when talking about the defects in the existing legislation, I think his view is misconceived and poor interpretation of the law. Because if you look at Article 82A and Section 8 of the Act, the wording opposition does not exist. It's my submission that it's a misnomer to talk about opposition. It does not exist under our law. You have opposition parties. So conscripting all opposition parties as opposition, that has never been the spirit of the law. And we invite this committee to look at the debates. When Parliament was amending the Constitution to create 82A and the Act itself. So, Honorable Chair and Honorable members, if you look at the Act, the definition of opposition, it does not talk about opposition parties. It talks about the party in opposition. So, to say there is opposition, that has been a very big mistake. We are parties in opposition. Why? We have separate manifestos. We come here differently. We actually elected different as FDC, but not as opposition. So now, this amendment, you don't have to amend because the law is clear. It's talking about the party in opposition, meaning the party with the second numerical strength is the party in opposition. It should appoint the LOP. Why? Because they have the alternative policy, and they should really be the ones doing the checks. You not now call all the other parties because there is no forum for you to do that. And this can be really seen when you look at the debates creating the office of leader of opposition, and also the debates in the Act operationalizing the constitutional provision. That is the first point. And we have specified these arguments under 2.0 up to 2.4. Honorable Chair, the other point we wanted to talk about, I think, which has been highlighted by my party in the party paper presented here, and submission by the President, that specifically this was not meant to create some bit of representation of members of parliament and a discussion forum. It was actually meant to ensure that alternative policy outside parliament is coordinated by a leader in parliament, specifically specifically to keep government in check. And if you look at Section 6E of the Act, and again 6.4, specifically it is clear. It is not giving this mandate to opposition political parties. It is actually creating alternative government in parliament. And that cannot be vested in a person who is appointed, what Honorable Mu talked about, democratically by all these other political parties. Then, Honorable Chair, under 2.4, I observe that the issue of representation cannot be implemented without confusion or disruption. We are all members of Parliament. Honorable Chair, I worked in a bank for quite some time and a group of companies from the age of 24, about 8 companies. I've taught law for over 27 years. I've been in private practice for over 30, but I've never worked in a difficult and challenging institution like a parliament. I've never. I came here when I was 81 kilograms without anything, not sickness. Within 6 months, I deteriorated to 64. And it's still going down. So,
staying in the committee, say aye, and to the contrary, nay.
Aye.
The ayes have.
Can I? Okay. I'll be very...
Chair, I have a procedural matter before, and I'm happy my colleague has introduced herself, and surely she put it clearly that she's not a member of the committee. And the rules, under Rule 206, you first have to approve. So, with your, is it procedurally right that you first approve her to also sit? Because as a member...
You want to object?
I don't want to object, but let it be approved first, because we might...
Staff.
They are handled here. Mr. Speaker, you see, I read this figure, I gave him the total, and I show
West Manafa District.
Bosco Kirol, Usuk County, Katakwi District, a humble member of this committee. Thank you.
Achayo Juliet Lodo, Member of Parliament for Ngora County.
Appreciate the team from NRM for, in a very candid manner, give us your views, which we shall, as a committee.
To say something for emphasis. Why we agreed with the position the Director Legal stated was that when you look at clause 1, where it says the amendment seeks to ensure that the leader of opposition represents the views and aspirations of all political parties. The question was, are the views the same? Because every party came there with their views. So at this moment, to purport to box them into one corner and have one view may be a little difficult. Because you're saying he's going to represent the views and the aspirations. Everybody came with different views. The other thing was Article 82 of the Constitution gives really discretion to Parliament to do this. But we thought that, and we have always seen that Parliament will exercise that discretion judiciously, and this is where we came out clear in this position, because our party chairman has always said that what NRM says during the day is what it says during the night. And therefore we expected that this discretion, Parliament would use its discretion very judiciously, not with suspicion. And that is why we are honest to this position that Director Legal has said. The other comment I wanted to say was, on the funding, the director made it clear that under another legal regime, where the money goes to Electoral Commission, money is given to parties in numerical strength. And therefore, if there was any feeling of parties getting that money, it is being catered for under that legal regime. And therefore, the money which is meant for an office X, in our opinion, it would be wrong to divide the money meant for office X to other parties. I thought we wanted to say that. And you see, even when you go to the draft, the text as it is, I think because of that wanting mind, the drafting was like to budget and allocate to the parties in opposition to government in parliament, in accordance to their, you see that jumping in the drafting to allocate what? To allocate, and it consistently in the draft, to allocate, meaning that in a kind of hasty mind, the drafts lady or draftsman also was not confident, because in other words was supposed to draft that to allocate money for opposition, leader of opposition, but I didn't want to commit that to allocate money for leader of opposition. So that hasty mind led to that kind of drafting. So I just wanted to say this, if it is for matters of emphasis or clarity, but the position is what the Director Legal has stated. I thank you.
Sorry. The Director Legal has said it all. When you look at the bill, there is nothing it wants to cure. Have we failed to do the work? Have we failed to conduct our business in Parliament? Has the opposition failed to conduct business because they have not elected the people, the opposition together? No. So for us, as NRM, we say we remain with the status quo. Thank you.
Thank you, Mr. Chairman. We are done with. Perhaps should not pass. We support the proposal in clause 4C in as far as it provides for discretionary consultation and does not seek to take away the rights and powers of the party with the highest numerical strength in Parliament. So clause 4C is the one that says that the leader of the opposition shall be required in consultation with opposition political parties represented in Parliament, appoint chairpersons and deputy chairpersons of standing committees, which are required to be chaired or deputized by members from the opposition. This will ensure that the views of the political parties are considered while appointing chairpersons and deputy chairpersons of the opposition committees. We do not find a problem with that proposal. We would support clause 4C. Now, those were the main, I think, proposals in the bill, and then there were the additional proposals. One was on the election of the commissioners, and the proposal is that Section 2 of the Principal Act be amended to provide that the two commissioners who are backbenchers, that term is introduced, should be elected and they should not belong to the same party. But the provisions of the Act as it is now are based on, again, the recognition of multi-party democracy. All these offices are based, because they are talking about numerical strength. That is our democracy. That is how it runs. So the underlying assumption is that the ruling party and that the party with the largest numbers not in government would generally represent the majority of Ugandans want the alternative of the other. So we propose that the amendment would take away that critical factor, and would think that there is no problem with that provision staying as it is. The other additional proposal was on budgeting for the LOP office. Again, we go back to the fact that this is an office, and the budgeting is done for the office. The budgeting is not done for the party or for the individual that is in the office. It is for the office. We take the view that it would not serve the purpose if you now spread that budget among political parties. You are not funding. It would assume that you have split the functions of that office among those political parties along some other line that we are not quite clear about. But also, as you know, the political parties already get funding based on their numerical strength. So this would run counter to that and would not, again, think that it serves the purpose which it is thought to be serving. And if that purpose itself, I think, is contrary to the office. So then there was a hypothetical presented. There is a provision, an additional proposal that is based on a hypothetical situation where a political party in the opposition, two political parties in the opposition, have the same number of MPs in parliament. Now, it is hard to deal with a hypothesis, but our view would be that it is unlikely. It is unlikely that you would have the second party in a general election. You would have a tie in the votes in the general election and have a tie in the members of parliament. Our view would be that the better way to solve that hypothetical situation would be to deal with the party that comes second in the general election. But that is still a hypothetical, and I say this with a lot of reservations because it is a hypothetical. It's a bit complicated to deal with. The final proposition in the additional proposals was the election again of the chief whip. I think this follows the same position that we have discussed regarding these elections. I think the chief whip also follows the same process of election. Incidentally, the law does not say that these people must be, for example, the chief whip should be elected from the party with the, should be an MP belonging to the party with the highest numerical advantage. It doesn't say that, but the appointment would come from that party. So, Honorable Chairperson and members, that is a high-level summary of our views on the bill. As my Secretary General has said, we shall be pleased to submit a formal written view on the matter.
Mr. Chairman, if you may, I can maybe invite my colleagues who are here with us to, if they have anything else to add on the presentation by the Director Legal. But the short and long of it is NRM, regardless of how opposition present themselves, whether in groups or individually, we just want a credible.
Thank you, honorable members of the committee, for inviting us. Indeed, I reiterate the appreciation expressed by the Secretary General for us being here. We have looked at the bill, the Administration of Parliament Amendment Bill 2024. We have looked at the objects of the bill, and we will comment on them as the matters on which they are the comment arise. We have also noted that there are some additional proposals in the bill which do not seem to be captured by the object of the bill. They appear to have been proposed by the mover of the bill subsequently. Nonetheless, as that is a matter entirely of procedure, we shall still address them, and we leave the rest of it to the committee and to Parliament. So on clause 1 of the bill proposes to change the definition of the leader of the opposition. The current act is that the current law is that the leader of the opposition is that person who is elected by the party in Parliament with the highest numerical strength. I think that is section 11. I must have misplaced my act somewhere. Now, we believe that to cast the leader of the opposition as such would go against the established traditional parliamentary systems in most of the Commonwealth jurisdictions. The leader of the opposition is typically a leader chosen by the largest political party not in government, and that position typically exists in multi-party democracies. Now, in fact, in other jurisdictions where it is completely a parliamentary democracy, the leader of the opposition naturally is the leader of the other party that has come second. But in our case, because we have some sort of hybrid, the leader of the opposition is not necessarily the leader of that party, but is elected or selected by that party that has come second. But I think for want of better language, the law talks about the biggest numerical strength in Parliament, because the leader of opposition is elected in Parliament. So that office is established by Article 81A of the Constitution, so it's a constitutional office. And we hold the view that the current definition aligns well with multi-party democracy. We do not think there is anything wrong with it, and we shall explain that later. Clause 2 is the one that proposes to have members of all the political parties in opposition in Parliament elect a leader of the opposition. Now, if we go back a little bit to the definition, the definition is assuming that the leader of the opposition is supposed to serve that party which he leads, which is not correct. The leader of the opposition is an office, it is established, it is there regardless of which party is in power or of which party comes second. So, but the office itself is established as the leader of the opposition with specific functions that are not delineated or are not limited to achieving the objectives of that political party. So we maintain that this runs contrary to multi-party democracy and negates the popular vote. When you look at the spirit of the law is that in a multi-party democracy, the party that achieves the biggest number of the popular vote forms government. It is that same spirit that says the other party that next achieves the next highest popular vote selects the leader of the opposition. So there is a popular vote to it, and you cannot purport to take that away. And so we think that an attempt to then subject that leader of opposition to the other political parties in the House would effectively be stripping the other political party of its right and power in some sense. So that is our position on that. We are inclined to suggest and propose that the law remain as is on that point. Clause 3, I will run through these fairly quickly because I assume everybody here has of course had the benefit of the bill. This clause seeks to add, that's clause 3, seeks to add a grounds upon which a leader of opposition can be removed. Now, all these things are a bit connected. So if you look at clause 1, making the definition, you look at clause 2, seeking to make the amendment, then you will find that there are several other things that lead to that. So once, for example, the idea that the leader of opposition is elected by other members of parliament, the other political parties, once that collapses, you will find that several other things linked to it would necessarily not make sense. So, following our submission on clause 2 and 1 that we have just made, we find that clause 3A and 3B are untenable. Those clauses, I can read them for us to just be sure. Clause 3A is about the leader of the opposition to be elected, and then clause 3B is the one that talks about a nomination of 3 persons from amongst whom the one will be elected. So naturally, those would collapse for the same reasons that we have given. Clause 3C provides for removal of the leader of opposition on account of inability to perform his functions. Sorry, I think I read the wrong one. Clause 3A was, these are about how to remove additional grounds for removal of leader of opposition. So one is ceasing to be a member of the political party in opposition to the government, having the greatest numerical strength. That is already covered by the law, which says if he ceases to be a member of that political party which elected him, that is automatic. So this is only proposed because it is based on changing the system. The second one is that he or she is removed from office of leader of opposition by a resolution of the members of the opposition parties in the parliament. Now, again, you can see here that the party now has lost its authority over its members and cannot discipline. And we think that for a multi-party democracy, the parties should be empowered, they should be strong, they should be allowed to grow. If you strip them, you keep stripping them, then we have a challenge. And since I have heard here that the proposal is to be effectuated at a future date, you never know who it will be. So we support the one that says he or she is unable to perform the functions of his or her office due infirmity of body or mind. That is natural, and that is a proposition that we support that can be added. There are 2 other propositions that are made in clause 3D and 3C, that he or she can be removed for being incompetent or for misbehavior. We find those problematic because they are too broad. They are too broad, and in their present state, they require now also some natural justice. How are you going to determine the incompetence? What if it is challenged? If it is challenged, it goes to court. In the meantime, we are stuck in Parliament, and what is happening? So we find those two grounds too broad. We do not see so far that they are curing a particular mischief outside the provisions that are already provided for. So clause 4 is the one that seeks to introduce the requirement that the shadow cabinet appointed by the leader of the opposition under section 11(2) of the current Act, Cap 272, be subject to approval of the members of the opposition parties in Parliament. Now, the current law talks about consultation, that you can consult. We do not find that problematic. We do not find that there is a mischief to be cured. And given our views on the nomination or election of the leader of opposition, we think that that one also
copies. Mr. Chairman, I was out of town and I came back last evening. I'm just in the process of polishing up the ideas and putting them together. I think before close of day or before midday tomorrow, we shall send an official written document to the committee. Yeah.
Thank you,
matter. On my part, Mr. Chairman, on behalf of the party, the National Resistance Movement Party, in its thinking, in its philosophy, wouldn't want to constrict itself into a thinking that makes everybody feels like we are not giving them a chance. We, as a party in government, we contested for leadership. Our manifesto was voted for, and just like another party that came to contest. And we are in leadership because of the popular vote by the people. And it is in our interest that we have opposition which is organized enough to challenge our activities of governance. In a way, we think that it's better to deal with an organized opposition. It's better to deal with an opposition that think through what it's supposed to oppose. And so critical thinking under multi-party political dispensation, we know there are many other political parties that equally so have members represented in Parliament, and therefore we feel all of them should participate in the governance process of this country. Now, having said that, we also know that the Constitution is very constraining, that parties contest for governance, and a winning party is voted for based on its manifesto, and the first runner-up becomes a leader of opposition. That has been the practice. And with the administration of Parliament, a leader of opposition is picked from the party that comes second in the national election. Now, we've been debating and seeing to what extent would such represent the interests of all other political parties in Parliament which are in opposition. And have we been able to get their views in many of these critical national issues? When a leader of opposition speaks in Parliament, does he or she speak on behalf of other political parties who are in opposition, or he or she speaks on behalf of his party that sponsors him to become a leader of opposition? Now, having looked at these two scenarios, I would therefore request that I invite the Director League of the party to take us through what the party feels could be the most appropriate way through in this. Thank you.
Thank you. As I also invite you to a large hour snack and a cup of... Thank you. And I'm Stephen Baka.
And I'm the Deputy Chair of this committee.
Staff.
Thank you, Chair. Bernard Odoi Onen Mutusa, Youth Eastern.
Thank you, Chair. My name is Bosco Kirore, Member of Parliament, representing the people of Wusuk County, that's in Kataku District, a member of this committee. Thank you.
Thank you, Chair. Achayo Juliet Lodo, Member of Parliament for Ngora County, member of this committee. Welcome, members of
Musinzi Yona, representing Tungama Municipality.
These are all format and have been helpful. Any other question? Okay. Now, honorable members, introduce yourselves.
Yes, you can catch the fever.
Moise Jebran, a lawyer, Directorate of External Affairs.
Charles Egowenwell, the Senior Executive Assistant to the Secretary General.
Honorable members, the Honorable
of the National Resistance Movement Party in Uganda. I have been accompanied by the Director Legal, Comrade Enoch Barata. I also have with me Commissioner Jane Alesemera, who is a commissioner with NRM Electoral Commission, and Comrade Awich Paula is the Director External Relations at the Party Secretariat. The rest are our support staff. I have. You introduce yourself. Should I introduce yourself?
So many and so the engagements tend to spill over into time of other stakeholders. And actually, as I talk, the next group is already here. The PPP party, they are already here. So honorable members will take it short, few questions, and I hope the NRM is now ready to proceed. But before I invite the Secretary General, I want to NUP exit. NUP exit. Colleagues, we don't have a break. We are connecting just straight. I wish now to take the opportunity to invite the NRM, the leader of the delegation will sit here, and the officials will follow. You are welcome, Mr. Secretary General.
Thank you so much, Honorable Chair of this committee and the distinguished members and also the team. We have put our position as the National Unity Platform Party in writing. We have, through the Secretary General, elaborately submitted on those positions. In conclusion, the constitutional provisions in terms of power belonging to the people and also the voice of the people is very, very critical. The aspirations of the people of Uganda is very, very critical. It's therefore our considered view and our considered prayer that this committee accepts holistically our submission and therefore rejects the bill in its entirety and ensure as it would and as further breakdown of the rule of law. Because I was from Arua, many people even have not had, many, including people who are land. So when we are talking about the consultations, we really need to, I just came back from Arua yesterday. People don't know. And it is only called the Honorable Lumu Amendment.
So, but who is Honorable Lumu? What is the amendment? So it is really our prayer that in the best interest of peace and stability and democracy, let further consideration be done. But even without wasting any more time, let this bill be rejected in entirety. Thank you.
Thank you. The unity, the national unity.
Especially regarding the question which was raised as to the vetting process that members of cabinet go through, to emphasize that the spirit behind that is the whole idea of creating checks and balances to limit the powers of the head of state, which is different from the appointment of the leader of opposition. And additionally, that the leader of opposition, unlike a vice president who can be picked from anywhere, is picked from amongst members of parliament. And he has already gone through the processes of establishing the minimum standards of appointment to this office. Yes, and further emphasize that the leader of government business and the leader of opposition are on assignment from their respective parties in accordance with the numerical strength as determined at the general elections. And therefore, to create a different mode of appointment for both in parliament is what is the premise of our argument that the proposed amendment would be discriminatory against in respect to appointment of the leader of opposition using a different mode from the one of appointing the leader of government business. Thank you.
Aware, indeed, the last time that the member was saying that it can, he proposed it as a by the way. He said, I have no problem. I watched that. He said, I have no problem for it commencing in the 12th Parliament. So the question we are looking at, what is the intention? Why now? Why in Gulu? We are looking at all these circumstances surrounding this bill. So that's why we are saying that maybe the whole idea behind this bill was that the current law refused maybe to draw a certain line, and then this law came up. So we insist that we think it was brought definitely in bad faith. If not just to target the current LOP, to target NUP as a political entity. I've already alluded to what happened to Honorable Zake when we designated him as a parliamentary commissioner and all the problems that he went through. Comrade.
Thank you very much, Honorable Chair and members of the court.
Indeed, returned money even about the age limit and all that, and that kind of thing. No, it went up to the court actually, and if you read the decision of the late Justice Kakulu, he referenced that, and he spoke about members of parliament who returned the money about the age limit bill. So yes, indeed, that matter went up to there. So the point we are making is that once you say that we are opening up this process, now the leader of opposition should be elected. I mean, different interests. It may not even be the ruling party. By the way, let me say this. It could be other interests. It could be a multinational company which is interested in having a leader of the opposition that they can control, which will come in and try to influence the processes as it were. The other question I wanted to say, I think it's Honorable Yona who alluded to the fact that what if the president is compromised? First of all, the leader of the opposition is not selected in NUP by the president, for example. It is NEC. We have a National Executive Committee, which is an organ of the party, which sits, deliberates, and elects a leader of the opposition. So that has to be very, very clear. Now, the other issue about discrimination, Honorable Niwagaba, I think really posed a question on discrimination, and I think one of the cardinal rules of interpretation, again, is you read the Constitution as a whole. Let's not just go the textualist way. Whereas the Constitution specifically provides for the appointment of the Prime Minister and not the leader of the opposition, our view is that once the law says one leads the government side in Parliament and another leads the opposition side in Parliament, then if you say that the mode of designation is different, there is discrimination in terms of the roles. You already
do. The Secretary General said it is a Roma.
There was. They gave me the floor, if I may. They gave me the floor, if I may.
On his time.
Yeah, okay, it will be quick. The history of Parliament has been clear. I will tell you that the 5 million deal to members of Parliament was known by everybody in the removal of term limits. Even in this very parliament, there has been the 40 million that we had recognition of. Members of parliament were bribed with 40 million shillings pursuant to passing particular bills. And that was not only in public knowledge, but also with evidence from members of parliament.
So what is the evidence? You said you are tabling evidence.
We have the evidence. If you want to table it, I can table testimonies of members of parliament once you give us time, but also we can be available for cross-examination of the speaker. And some returned the money, actually, to give you evidence more.
Conclude.
Thank you so much, Chair. So actually, like I said, it is public knowledge. You know, even this went up to the Constitution. Again, not agree with it, because not every senior leader in Parliament is subjected to vetting by the Appointments Committee, including the Speaker, the Chief Opposition Whip, the Government Whip, and others. And the whole idea, really, and I think this is, you are talking about rules of interpretation. For me, I think one of the things that should guide this committee, honorable members, is the contextual interpretation, the context in which we operate. We are operating in Uganda, and we know the challenges that have affected our democracy and the challenges that we continue to grapple with as a country. So when, for example, I talk about the possibility of some members being compromised, it is, allegations have been there in the past that many processes, right from the amendment to remove the term limits, this is public knowledge that money exchanged hands, these things are in the public realm. So it is not something we are making up. We have talked about Yala, and we've seen all these allegations that keep coming up. So we are saying that in order to protect this nascent democracy that we're trying to build, let us not open a room through which evil will come to completely dismantle the little that the opposition is left with in this country.
Responding to the concern you raised about the approval of the Vice President and the Prime Minister by the entire House. And that is it was buttressed by Council Nwagaba, Article 82A versus Article 108. Mr. Chairman, in the wisdom of the framers of the law, the Constitution, and even the enabling law, that Administration of Parliament Act, they knew the mantra which says the majority will always have their way and the minority will only stop at their say. If in their wisdom they realize that given the numerical strength of the ruling government, it would be just for formality to whip them. And by the way, the role of the government chief whip in Rule 15, Sub-Rule 2, apart from ensuring due attendance and the participation of members in the proceedings, the most important one is whipping members in voting for the position of the ruling party. Now, if it ever happened that you subjected this leader of the opposition, who suffers from numerical strength, we are now looking at opposition, the number of members in the opposition compared to the majority of the mass party. The members, the government chief whip, definitely at any one given time can whip all his membership to vote out a given leader of the opposition. And that one, by the way, Mr. Chairman and honorable members, we are rivals, rivaling the two parties, the opposition and the ruling party, are rivals. One would not want a very smart, that official position to come up with a very smart leader of opposition who will give them sleepless nights. So they will keep throwing your appointment, nomination is out every other time until you bring the one they know may not meet the threshold. So in the wisdom of the framers, they looked at the numbers. And the democracy is about numbers. That's why they saw that Prime Minister and Vice President are appointees of the ruling party. And there is no way they can turn against their own, because the caucus will be whipped in line to vote for them. But it would be a complete opposite if you subjected the same on these minorities. And that's why the framers, in their wisdom, did that. But also concluding, Mr. Speaker, Mr. Chairman, about Honorable Nwagaba's the addition, I think a clause was introduced, an additional one of more commissioners. That one is answered by Article 93. It would impose it automatically. And I don't think this would even qualify for a certificate of financial implications if it was going to impose a charge on the consolidated fund. And I think that's why it would not arise. Thank you very much.
By government and compromising them to elect a leader of opposition that is not the candidate of your choice. I'm a bit perplexed. Are you specifically alluding to the character of the current MPs in the National Unity Platform or generally? Because I find this a very serious allegation that, when put on record, compromises the integrity not only of the House generally, but especially the members of opposition, whom we have always held in high esteem and without any possibility of being bribed, because they represent decorum. So when you put it categorically that that is one of the easiest and possible avenues, I feel they have been bundled up probably for wrong considerations. Secondly, the move of the bill had proposed on record here that he wishes the commencement date to be with the 12th Parliament. And you seem to suggest that the bill is targeting the current leader of opposition. Are you privy to the fact that he specifically and categorically stated that the commencement date should be 2026 with the 12th Parliament? Thank you.
You can share out the responses with you.
For other political parties and the effect it has on Article 93 of the Constitution, and actually the effect it has on discriminating other forms of shades of opinion in Parliament, including the UPDF and the independents.